Hi everyone, I'm Andrew Kilgore, Director of Broker Relationships at Lorega. Thank you so much for joining our webinar today on the perils of alleging fraud. We have two excellent presenters for you. Sitting next to me is Angus Tucker, Managing Director of Lorega Solutions Chartered Loss Adjusters. And our special guest presenter that you can also see on the screen is Dan Brooks, partner at Wynterhill Solicitors. So I'm going to move the screen across to Angus. We'll start the presentation. Just a couple of housekeeping things. We are recording this presentation. Please be aware of that. We'll be sending out a recording to everyone within the next couple of days. If you do have any questions at all while the presentation is going on, you'll see on your Zoom toolbar a Q&A option. If you just click on the Q&A option, you'll be able to put your questions in there and we'll pick up those questions at the end. So I'll pass now across to Angus and we'll get started.
Thank you, Andrew. Welcome, everyone. Good afternoon, as it's now just past 12 o'clock. Welcome to the webinar. This is the first of hopefully a number of joint webinars that Lorega and Wynterhill are giving. As many of you may be aware, Wynterhill are the legal partners of Lorega. They are specialist insurance lawyers who act for policyholders, so obviously a real synergy with us and support the work that we do on disputed claims. So what are we looking to cover? What Dan and I hope to do, we'll be looking first of all, the fraud is an issue. I mean, everyone agrees in the industry that it is a major concern, but equally, insurers shouldn't use that as an excuse to hide behind fraud allegations and try and reduce or refute claims or give the policyholder a hard time. And we're looking at those cases where innocent policyholders can get caught up at no fault of their own in a fraud investigation. I'll be looking at the initial fire. We're basing this around, say, a major fire claim. Obviously, you can have a fraud in virtually any type of claim, but the sort of examples we give or references to are based on a fire claim. So I'll be looking at the initial process when a fire occurs from the adjusting side and the issues that possibly could arise, and then looking at what the insurer coverage investigation would normally cover and how that might involve the policyholder. Then passing over to Dan for the legal aspects. He'll be covering when things go wrong, and that will include an anonymous case study, looking at the burden of proof on a claim, and then probably a very important one, challenging an insurer's avoidance of policy decision, how that can be challenged. Then involvement in the Ombudsman, what that incurs, and then the conclusions that we've drawn from this. I'm very much looking at this. I know most of you who are brokers there, you'll be aware of Lorega loss recovery insurance, and if we're involved, we can assist in managing the process if it's a loss recovery one. I'm trying to look at this, especially initially, where you have clients who say don't have loss recovery, and how you can assist and advise them where to try and prevent these issues coming up. So moving on to the first slide. First of all, a very good quote there that that Dan's put in from Sherlock Holmes, which we'll come back to at the end of the presentation. So the initial process, what does that cover? Well, obviously, the first thing is notification of loss. It's very important on any claim, but there's certainly claims where there might be potential issues that could be misinterpreted. A notification of loss to the insurer should be as soon as possible. I'm sure you all instill in your clients that if they have a loss, especially a major loss, they should notify you as their broker immediately so that you or they can notify the insurer. There's a policy requirement in any event for notification time, and there's a need to comply with the policy limits, so you're not out the time limits, so you're not outside those. Also, the sooner the better. Memories are still fresh for what's happened and for getting information, background information. Appointment of adjusters by the insurers. that needs to be as soon as possible so that the investigation can get underway. Normally, the insurers should do that immediately. However, it doesn't always happen. Some insurers might take time. And if insurers are dallying a bit on appointing someone, they should be chased for that. And it's important too that the policyholder and you as the broker have these details and notification of who they are and contact details straight away. First contact and the site visit, but by the insurer's representatives, again, that needs to be as soon as possible. Then there needs to be a contact really by the policyholder or their representative as soon as possible to the insurer's adjuster to sort of visit out. Initial visit, especially on a major claim, it may be restricted as to what can be done with regards to the actual site visit. Blue light services could well have cordoned off the area, the fire brigade or the police. The fire may still be burning or smouldering. There may be a police investigation, especially if someone was injured in the fire. And it may be some days before access is granted, but that shouldn't delay an initial meeting and investigation. At that first visit, it's important, I would suggest, especially if there's any suggestion of potential issues, the policyholder should have a representative there. You as their broker should be attending, I think, to assist them. And it's important as well, at that very first meeting, not to organise a time visit with the insurer's adjuster and all roll up at the same time. As the representative of the policyholder, you should, and we would always, if we're involved, look to meet with them an hour or so before the insurer's adjuster is attending, to get details, get a feel for the loss before the insurer's adjuster attends, and before, not always, but occasionally the insurer's adjuster, there may be high pressure questions banging out to the policyholder that we need a discussion with them before there's that pressure on them. Identification of potential damage and value, that's part of the initial process and very important, a bit of a crystal ball area. It's important too to identify whether or not it's above or below £100,000, because generally that will dictate the level of expertise and the type of adjuster the insurer appointing. And also a number of insurers, any claim over £100,000, the fire claim, they'll automatically appoint forensic investigation, whatever the cause. Securing evidence, loss mitigation measures, that's important. Policyholder needs to do what's best for the business recovery, but also be seen to be doing it. It could be a red flag for an insurer if they think the insured's sitting back, not bothered about the business recovery. That might cause concerns. Securing evidence is absolutely vital. Under the policy, the insured can't abandon anything and can't get rid of anything without insurers' permission. And insurers have declined claims in the past where forensic investigation was prejudiced by the policyholder cleaning everything up and getting rid of things. So policyholders should always be told to, in a fire, the area where the fire occurred, secure that, don't touch it, don't contaminate it, cordon it off if necessary, and then the remaining area can be cleaned up to allow loss mitigation. Taking lots of photographs also at that point is important. Identification of potential problem areas is very important at the outset. Who's the insurer? That itself can flag up a problem for us on the policyholder side. Some insurers are quite notorious about a quite aggressive approach to investigation. Same applies to their loss adjusters. There are a lot of very good ones around, some not so good who are notorious for being confrontational or causing problems. Equally, our client, our joint, your client as the broker, if it's loss recovery, our joint client, what are they like? Some policy, everyone's human, and I'm sure we've all got clients who are quite belligerent, have a very short fuse, can blow their top at the slightest thing, and if there's some confrontational stuff coming from the insurer's adjuster, their approach can add to the problem. We also need to very quickly identify at the outset any potential non-disclosures, such as undeclared CCJs or previous insolvencies, which sometimes come out of the woodwork the policyholder hasn't told you at inception. So typical insurance coverage investigation, what to expect. certainly in a major fire claim, the insurers, no doubt, and their adjusters will be doing background checks instantly online on the policyholder and the business and the trading of it from the point that they're instructed, as well as asking relevant questions. Again, this is why we would always say it's important for a representative for the insured to be present at the outset to assist the policyholder and guide him through what to answer. Circumstances and the cause of the fire, it's all standard information gathering. There's an onus to cooperate with the insurers and give them the background information, and that's quite right. We would always advise the policyholder at the outset. We often get asked, what do I say to the insurers? What don't I say? We always say, be open, be honest. Don't try and hide anything. If there's any problems, we need to get them out in the open immediately and sorted. If they do keep anything back, and that it will invariably come out later down the line, and the insurers then will start having doubts about all the other information that was given early on. Fire services report and an interview, the insurers or their representatives may ask for that. That normally goes along with forensic investigation. On the forensic investigation, if there are any questions or doubts about the cause, and there might be slight concern about how that might impinge on the insured, the first question you should ask then is, does the insured need their own forensic investigation? That may be very important to challenge something the insurer's investigation says later on. And if they do, it's vital to make a quick decision on that and get that investigation in parallel with the insurer's one before the insurer's forensic taints the evidence or it disappears while they're doing their investigation. What happens, the insurers or their representative may request interviews with the management of staff. Is that request reasonable? Why do they want it? Why do they need to interview so many people? Is there a need for legal advice? There may well be here. There's certainly a need for the policyholder to have someone assisting them and a representative there at such an interview. Also, we need to clarify what is the basis that they're doing the interview. Is it under PACE regulations? We need to know what we're being faced with there. Also, I'd always say that don't let the insurer's investigator take handwritten notes during the interview and then immediately insist on the insured signing every page at that time before even really reading it. If I'm involved in anything in the early days like this, I would always request that before anything is confirmed and agreed, they have the handwritten notes typed up so that they can be read correctly and then emailed back to the insured and their representative to review carefully before anything is signed and confirmed and agreed. Who are the parties involved? You will meet the insurer's loss adjuster. They may then have either the loss adjuster or the insurer's fraud investigator may appear, and that's an immediate red flag for the policyholder and our side as to why are they doing that, what's the problem, and there may be an insurer panel lawyer involved as well coming in. Dan, if I can pass over to you now, please.
Certainly. Thanks, Angus, and thanks to Andrew for inviting me to speak today as well, and welcome to all of our audience. Angus, there were some good tips in what you said there about how you handle interviews, for example, and I'm going to sort of dovetail that initially before moving on to the case study. I've been desperately ambitious in trying to cover far too much today, Angus, so I'm going to sort of rattle through as much as I can, and what I'd suggest to anyone who's listening, if you have questions, if you feel that I've glossed over anything and you'd like to speak with me or ask a question that doesn't get dealt with in the Q&A at the end, then drop me a line, give me a call, and I'll do my best to help. But look, just kicking off, in terms of when it starts to go wrong, there's sort of three indicators really, Angus, isn't there? The first one is the reservation of rights that we frequently see as policyholders. That's quite a frustrating experience, I think, for policyholders and for those advising them, brokers and claims consultants and coverage lawyers alike. Frustratingly, there's very little that we can do to compel an insurer to tell us exactly what it is that's bothering them, exactly what the coverage issue is that they're looking at. Sometimes it will be obvious on the facts, sometimes it's not. And I think, my only sort of practical suggestion is, to sort of pick up the phone really to the claims handler, the adjuster, or even the panel lawyer to see whether you can elicit anything from them, sort of to give you a steer so that you can prepare the policyholder and advise them appropriately. There is a lot more to say about reservation of rights. I'm not going to dwell on it. There is a useful document on AMEC's website. I have attached the link, the hyperlink in the slides for anyone that wants to know more about that. Do take a look. There's certainly strategies if you're a larger corporate, but if you're an SME, I think there's probably little that you can do really to stop that sort of reservation of rights process. But moving on, the sort of second flag, second warning sign is, of course, the request to attend an interview. You touched on it, Angus. The request to speak to the management team, more than one person, or the consumer if it's a consumer involved. That request can be troublesome because at one end of the spectrum, you'll have those policyholders and insurers that want to say no, and that can give rise to possibly legitimately, if there's not good explanation, simply saying no and refusing to engage. That can give rise to an allegation of failure to cooperate. But at the other end of the spectrum, those policyholders, particularly the naive policyholders who haven't had appropriate advice, that don't understand what that interview is designed for, who the people are attending, in particular the fact that adjusters and specialist fraud investigators are there on the insurer's behalf. It can be quite risky to attend without appropriate advice. And my sort of practical suggestion really, and this may or may not be controversial, but my practical suggestion is that no policyholder should really attend either an informal or a formal interview, in particular, attend an interview without having asked for an agenda from the adjuster, from the panel lawyer, from the insurer direct, to understand what it is that they want to ask about, the questions and issues, and particularly to make sure that the policyholder can properly consider that, consider how they're going to answer those questions, and make an informed decision about whether or not they want to attend. Alternatively, whether it's better to give answers in writing to those questions. And I think anyone, if you're a policyholder, saying to an insurer that you will attend an interview in person on condition that there is an agenda, and the insurer refuses, as they do sometimes, to tell you what that agenda is, then in my view, that's definitely not a failure to cooperate under the terms and conditions of the policy. You do get some wordings out there in the market that require a policyholder to prepare, at the request of an insurer, a witness statement. I don't see them often, but you do see them in the market sometimes, Angus. I'm sure you've seen them. But unless you've got a very clear and specific term to that effect, in my view, a policyholder isn't actually obliged to attend at the will of an insurer to answer or to be cross-examined about things necessarily. So just moving on, the third thing to say, you've touched on it, Angus, but once you've made the decision to attend an interview, what's really important if you're an insurance broker or a claims consultant or anyone else advising the policyholder for that matter, including a coverage lawyer like myself, you need to give all of those warnings long before the interview. You need to make sure the policyholder has read the policy terms and conditions, and any unusual conditions or obligations in particular. You need to think about the issues. You need to think about what the cause of the fire was and what the insurer may or may not be looking at. And certainly whilst the interview is sort of taking place, the policyholder needs to understand that they can get up and leave at any time they want. They can ask for more time if they want. They can ask for, to look at their documents if they want to, and to confirm an answer to a question after the event. All those types of things would be my practical suggestion. But sometimes you go through all of those things, and even with the best intentions, as you've alluded to, Angus, you can't stop a naive policyholder saying something that they later regret, that later gets used against them in circumstances where the cause of the fire is accidental, is an insured peril, isn't fraudulent, but out of naivety, or even in some circumstances, I see it where the policyholder is trying to second guess what answer the adjuster actually wants, and instead of giving a matter of fact answer about what happened, where they were, items that have been damaged, I have seen circumstances where they sort of filter their own response, and that can be seized upon by an adjuster or a fraud investigator or a lawyer to allege a sort of secondary cause of action, a secondary fraud claim based on a false statement during the claims investigation stage. And I've seen that quite a lot, where insurers interview a naive policyholder in circumstances where their sort of primary thinking is that there's a deliberate cause of a fire, a deliberate start of a fire, and that later sort of dissipates and sort of falls apart when you start unpicking it. And then they sort of major on the secondary issues, the backup argument, which is their sort of get out of free jail card, leaving aside the law on sort of vers salute in cases like that, which is a topic for another day, hopefully. So look, moving on, I want to give people a flavour of an anonymised situation, a client that I acted for in what I think are quite shocking circumstances, to be honest, that really sort of get my back up as a policyholder coverage lawyer about the way in which policyholders are treated. And I'm going to come back to that in the conclusions and takeaways, because I think it's a potential issue in the industry right now. But it's shocking for two reasons. One, this was an accidental fire. The policyholders were actually residential owners, Angus. I don't often act for consumers or residential policyholders. Most of my work tends to be for larger corporates, particularly. But every now and then you get asked to act for a client in circumstances where you can see fundamentally something has gone wrong, and fundamentally the treatment of the policyholder isn't right. And what happened in this case, after the fire, they were in a hotel, being put up and paid for by insurers. The fraud flare went up because insurers essentially established that two contractors, potentially three contractors, who were tendering for the reinstatement works to rebuild, their semi-detached property in North London, worth about £1 million, following an accidental fire. Insurers were able to demonstrate that the contractors had been sharing information and looking at each other's documents, and so obviously the tender process was unlawful on that basis alone. But further still, the theory was that the scope of works prepared and the tenders that flowed from the scope of works that had been designed, prepared by a professional surveyor, managed by a professional claims consultant. The allegation was that the quantum of those tenders submitted had been inflated and deliberately inflated in order to deceive the insurer. And there must be people in the audience thinking, well, so what? Someone tendering for reinstatement works isn't the client's agent, and they'd be right to think that and say that. And so insurers had, in this case, following an interview, in which inconsistent answers were given by the policyholder about where they found the contractor and their relationships with the contractor. The sort of fraud flare went up, Angus, and you could tell from that point on the insurers sort of doubled down on the sort of theory that the policyholder had conspired, in particular Mr. Policyholder had conspired with the contractors because he was in the construction industry, albeit he was a one-man band glazing contractor, not a contractor that does tendering often. But insurers' theory was that this was a clear conspiracy in which the policyholders were part of it were either aware that the contractors were liaising with each other to inflate the quantum of the claim, or had procured it, or had condoned it. And so from that point on, there was a very aggressive investigation of the claim. Mistakes were made during the interview process. We were involved a bit later, shortly before the policy avoidance, but the policy was avoided, which is obviously a very serious thing for anyone, in particular for policyholders who then would struggle to get insurance, for their property. It obviously goes on the insurance databases for fraud, and you can be criminally prosecuted. It's rare, but you can be criminally prosecuted for fraud, and of course insurers can pursue you for all of those losses. So it's a very serious situation, but there's a human element to this story as well, Angus, which is, this was a young family with kids in school who were in a hotel, who suddenly couldn't pay for the hotel, and had to move back into a fire damaged property, which disrupted their school children's life, and had quite serious ramifications for the policyholders in terms of their health, quite genuinely. In terms of our involvement, we had the challenge of trying to unwind insurers' policy avoidance, and one of the interesting things, again, we spoke about aggression, but in the policy avoidance and in my sort of subsequent email to the head of fraud at a well-known panel lawyer, the response that I got, quite incredibly to me, challenging him legitimately on a number of issues, his response was, we're not going to discuss it. If you want to argue about it and you want to dispute it, we have instructions to accept legal proceedings. And that was their response, and they refused to engage. So it sort of shows you how toxic it was by the time we were involved, which then gives you sort of strategic questions about what you do for the policyholder. The other thing to sort of quickly say about why it was shocking, as an aside, it was that in my very first telephone call with a very experienced lawyer on the other side, it was suggested to me that Wynterhill were part of the sort of machine of pursuing dishonest claims. So it was said to me, along with the particular loss assessor involved, which is obviously quite a scandalous thing to say, particularly as a solicitor, to be accused that we were actually part of this in pursuing a claim that was somehow dodgy in some way, and we were facilitating it. So it shows you from very early doors what I perceive to be unconscious bias on the defence side in some of these claims investigations. We need to watch for this, and we've talked about how to manage that. I'm going to come back to the ombudsman process and my sort of mentality. The things that I thought about, once the policy had been avoided, because there's some important stuff there for anyone, advising a client in that scenario, the sort of things that need to think about evidentially. But let me just come back to burden of proof, because this is important. The usual rule, of course, the usual burden of proof of proving an insurance claim, i.e. proving that an insured peril has arisen, the insuring clause is triggered, and that you suffered damage or loss, that obviously rests with the policyholder. That's not controversial, and nor is the fact that the burden of proof when a policy defence is raised, in particular when an allegation of dishonesty or fraud is alleged, it's obviously the burden of proof rests with the insurance company. But just to add to that, in terms of balance, the burden of proof, the normal burden is balance of probabilities, more likely than not 51%, that type of thing in civil claims and insurance claims. Insurance fraud, allegations of insurance fraud are different, and the courts do require strong and cogent evidence from insurers of allegations of dishonesty and fraud. They're not going to accept speculation. They're not going to accept, a suspicion. insurers are going to have to do a lot to join all the dots, and they will struggle. It's not impossible, but they will certainly struggle on an inference in and of itself, to be relying just on an inference of what happened, and that the insured deliberately caused the fire or procured the fire or did something after the event that was dishonest or fraudulent. They're going to need really cast iron, strong and cogent evidence. And the more scandalous the allegations, the stronger the evidence. And what I'd encourage anyone to do is, I've again attached hyperlinks to a number of reported decisions that are very interesting, because they show you how a judge will deal with these sorts of tricky situations and tricky coverage disputes, and it will show you, their thought processes and their considerations of forensic evidence, Angus, documents, but in particular, it will show you the weight that they attach to the credibility of the policyholder and their own evidence, on cross-examination. And I'll come back to that in a minute. So I've added a couple of hyperlinks. I'm not going to go through those cases. I would encourage people to read the Farid Yeganeh and Zurich Insurance case. That was a 2010 decision that was appealed from the High Court, and the initial decision went for insurers but was overturned on the Court of Appeal. And I mention this briefly because it's sort of, you can see why there was a suspicion of fraud, and some of the damage of loss, Angus, that was being claimed by the policyholder, a property developer, following the fire, which was said to be deliberate but actually proven to be accidental in the court case. This chap who the judge called a snappy dresser claimed no less than 7 Hugo Boss suits and no less than 70 Hugo Boss shirts at 90 quid a pop. And, to you and I, that may seem, unusual. But, when reading this case, what's actually important, and you touched on it, Angus, was the importance of having your own forensic evidence to undermine insurer's case, which in that decision was fundamental to prove that the policyholder didn't have any of these items. In that case, there was competing forensic evidence that did find fabric in the room where the fire occurred to support the damage and loss being claimed. So I mentioned that in passing, probably being sidetracked a little bit, but it's a fascinating case, and it shows you, it really emphasizes the high burden. So look, moving on, because we don't have a huge amount of time. What's my thought process? What should brokers' thought processes be when policy avoidance happens? Okay, if they want, or a claims consultant or a claims adjuster, if they don't want to take legal advice and they want to help themselves, well, what should they be doing? Well, a couple of quick things from me. I always, before I even agree to act for anyone, in situations like this, I will only act for that person or company if I meet the people, the key people involved, and have an opportunity to look them in the eye on a human level, put them at ease, explain that I'm on their side, not an insurer's side, and try to get the human story, and try to assess whether actually we're talking about someone that is genuinely honest, but just been caught up naively, or whether actually, and I have had this, and I do, Angus, and I'm sure you get it as well, turn down the request to act for some people in circumstances or situations in which I get a sense that the policyholder is not being straight with me. Once I get over that hurdle, and I've had many a policyholder, in my office sit there and cry, having grown men sort of cry about the situation that they're in because of those consequences for them, saying to me, how do I prove that I've not done this? How do you do that? You just get a sense of, a real sense of them and how they may come across on cross-examination, and it flows from there, because once you get there as a claims professional, it's all about challenging insurers' mindset, their forensics, their documents, their theory, the motive. You've really got to get under the bonnet of it and find the sort of human story in all of it. And if silly things have been said by the policyholder, the quicker we can sort of establish why they said something and correct it, there are opportunities to turn it around in those early stages. The second big thing, of course, and I've alluded to this, is immediately the one big difference between disputed fraud claims and other disputed coverage disputes is it is difficult, if not impossible, to settle a contested fraud claim by negotiation. I've never achieved it. I've only been, it's all or nothing. You either go the distance to court, to an ombudsman, to an arbitrator, and you win or lose, because it's so political, Angus, as you've alluded to. And what that means as claims professionals, what that means for me as a coverage lawyer, is that on day one, I need to be thinking about what evidence do I need to be able to persuade an independent third party. And by that, I mean an ombudsman, a judge, or an arbitrator. And I'll be thinking about documents. I'll be thinking in particular about forensic evidence. I'll be thinking about witness statements, who from, what about, and I'll be mapping it out in that very early stage, the whole case, for reasons which I've alluded to, and for reasons which I'm going to come on to in relation to the ombudsman process. So just mindful of time, I'm going to move on quite quickly, because I do want an opportunity, Andrew, to let people ask questions. And Angus, you may have some questions for me as well. But in terms of the ombudsman, in my anonymous case study, where there was, it seemed to me, very speculative, allegations of conspiracy to inflate the quantum of the claim. There was lots of other facts that I've glossed over in relation to the way in which the tender was handled by people, and other naive mistakes were made. But in relation to this anonymous case study, my advice for this consumer and for any consumer was to, put it to the ombudsman. And the reason why I do that, two reasons. Obviously, when you embark on litigation, court process, or an arbitration process, there are consequences for getting that wrong, quite serious consequences. And if you're running litigation to trial or arbitration to trial, you are going to be looking at serious money to get you there. But more importantly, you're going to be looking at a serious cost liability if you go the whole distance and get it wrong. For what it could be the fault of someone else. But if you go the whole distance, get it wrong, that policy, you could be making a bad situation a lot worse. The ombudsman process, by contrast, their role isn't to cross-examine the witnesses. Okay, you're not going to have a trial process. You're not going to have a hearing. You're not going to have a formal sort of CPR disclosure process. You're not going to have witness statements necessarily. You may choose to submit witness statements, as I did in my anonymous case study. But the ombudsman, unlike a judge, will have a very different approach based on what's fair and reasonable, but also based on sort of, burdens of proof, etc., as I've alluded to. So in my anonymized case study, what I did that I'd recommend that other people do is think about that evidence, prepare the evidence as part of the complaint. So I prepared witness statements that hadn't been taken, questions hadn't been asked in the way that they needed to be asked, and we prepared witness statement for Mr. and Mrs. policyholder. We also had thought about the whole case, and sort of were able to sort of reframe it, and on an assertion by assertion, assumption by assumption basis, which it wasn't too difficult on this case because it was quite speculative. We were able to sort of put a very convincing complaint together in very normal language, 10 to 12 pages long, with witness statements as annexes, that essentially was before the ombudsman, that gave them something extra other than just the insurer's report, Angus, just their say-so about what the cause was and the forensics, which is all very one-sided. You see, you've got one shot to put it before the ombudsman, and that's what we did, and that's what would be my advice to any claims consultant, claims broker who is thinking about, supporting their policyholders to make these sorts of things. The one downside of the ombudsman process is costs. If you are successful and you accept that decision, it is final and binding on the insurer. subject to a process of judicial review. That doesn't happen often. I've never seen that. It is theoretically possible, but once you've managed to overturn the decision, and in the case that I referred to, we were, we were successful sort of at every stage of the Ombudsman process, but it was appealed and eventually found for the policyholder and the policy reinstated. Unfortunately, we didn't recover our costs. So that's part of the challenge, I think, of sort of obtaining legal advice in that stage. Investing in the way that I suggested, it's going to be quite difficult, to potentially fund. It's one of the problems that you need to be thinking about on day one, and it's one of the pros and cons of, the court and arbitration process to contrast. I'm just mindful of time, Andrew. We've got a sort of few conclusions on the slides in terms of practical takeaways, but I want an opportunity.
Dan, keep going.
That's right. I'm going to finish now and sort of allow Angus to come back and ask a question, and anyone else. But essentially, I just want to sort of echo something that Angus mentioned at the beginning. Dishonesty and fraud is the scourge in our society. It's the scourge in the insurance industry. None of us, it's in none of our interests to have dishonest or fraudulent claims paid. Statistically, there were 107,000 purportedly fraudulent claims made in 2019, worth a total of 1.2 billion, according to the API. We've just had COVID, we've just had lockdown, and a lot of the commentators and a lot of people sort of know-how about these sorts of issues, are on the lookout for increased levels of dishonesty and fraud, and rightly so. But here's my sort of dilemma, and here's my question for the audience and for claims professionals. The risk of additional fraudulent claims is increasing, but my concern, the risk for me, is the risk of increased overzealous fraud investigations, in which innocent or naive policyholders get caught up because of the unusual circumstances of the claim. My concern is that there will be more and more policyholders who essentially are defending allegations of fraud, policy avoided, because of the sort of teams of lawyers and experts that are working on this, the other side. So I think our challenge as professionals, our challenge as an industry, is to work on protocols and think about best practice, and to make sure that policyholders are properly advised before, when these red signs, red flags, occur, before the policy is avoidance, on the occurrence of a reservation of rights, on the request of an interview, and when attending an interview. They are our opportunities to steer the ship in a different direction. But I think we could do a lot more as professionals, and a lot more as an industry, to build best practice around stuff like this, to ensure that customers genuinely are treated fairly. And I'm going to leave it there, Andrew.
Thanks, Dan. That was really interesting and covered a lot of areas. And one thing that I think to keep in mind, and it's something insurers and their team and the early stages don't. I mean, as we know, one of the areas that the FCA are very keen on these days across the board on anything and to do with people is vulnerable customers. And what is a vulnerable customer? After having dealt with claims for as many years as I have, to be honest, in my view, every policyholder who's experienced a claim, and especially like a major fire claim, is a vulnerable customer following it. I mean, it's a traumatic experience, whether it's your house that's burnt down around you, or whether your business has gone up in smoke, literally, and you don't know whether you're going to survive. They are in a vulnerable position. Yet insurers and the way that they treat sometimes policyholders, and certainly fraud investigators, don't seem to take that into account. I mean, I suppose it's inevitable, really. But again, ones I've been involved in where a fraud investigator has brought in, I mean, their whole life has been spent investigating crime or fraud, and they seem to have a understandable approach on that. Well, every claim they've dealt with they think is fraudulent, so every claim must be fraudulent. But I think also you've got a very good point here on the conclusion about challenging the insured. I mean, the insured as a vulnerable customer, they can often say, being naive, they can say very silly or stupid things, because we're all human, you know, incredibly stupid things. But being stupid is not against the law, and it's not, and it doesn't breach the policy. So they shouldn't be held back for that. And I think things that don't seem credible in the early days, our role includes playing devil's advocate and actually challenging them on anything that we've got a question mark about or doesn't seem credible, purely so that we've got the answer for when we're discussing it with the insurers. Actually, if I just bounce one back to you about reservation of rights, I mean, one issue that we see is that insurers put up a reservation of rights, so they haven't denied liability, but they haven't accepted liability. And we could be in a position sometimes months down the line where they still haven't accepted or denied, and you don't know, you can't address the issue because they won't tell you. I mean, under the new Insurance Act, yes, insurers have to be allowed a reasonable time to investigate a claim. But I mean, in your view, what is a reasonable time frame before insurers have just gone too far and refusing to address the reservation of rights and make a decision?
Yeah, it's a good question. Good question. I mean, I'd originally started with a slide on Enterprise Act claims, Angus, but I didn't think we had time to sort of go through it. But it's a really good question. You know, I mean, there's been a recent case on the Enterprise Act. I think it was a Butcher decision in the commercial court. And his starting point really was that sort of insurers, even at the sort of more complicated end of the spectrum of claims, you know, a year to investigate and confirm cover is a sort of held to be a reasonable period on those particular facts, but that had some international elements that had textures of color and textures of potential fraud involved. So that's one end of the spectrum, and likewise, you know, pure fraud investigations in the PDPI context, you know, insurers are going to get the benefit of doubt, and given enough time to properly investigate, interview, ask questions, take advice. And I think the Ombudsman actually said, in my case, Angus, which gives you an example, said that quite similarly, that I think insurers had it for 18 months before they actually avoided. It may have been slightly longer than that. It may have even been closer to 20 or 22. And they found that actually was an unreasonable period in which insurers had, and they should have confirmed cover for it. So it depends, you know, it's always very fact specific. In fraud claims, I'd say a minimum of a year to go through all of those processes, really, to answer your question.
Thanks. Do you have a look at the Q&As, Andrew?
Yes, great. Angus and Dan, thank you so much for sharing your expertise with us today. It's been really interesting. We'll just stop sharing the screen, and there are some questions in the Q&A. So we'll just take a look at these and see if you'd like to answer those.
Want to go first, Angus, or shall I?
Well, it's probably an easy one to answer. There's a question here. It's asking who pays for an independent forensic investigation where Lorega are dealing with the loss. If the policyholder requires their own forensic investigation, as if they require any sort of professional advice, like a surveyor, that type of thing, the policyholder is responsible for that cost. And that's a good point, Dan. What's your view, Dan, if at the early days it's felt that we're not happy with the way the insurer's forensic investigation may be going, and on behalf of the policyholder, they have their own forensic investigation, which successfully challenges the insurer's one. If the insurer's one is saying that it was, you know, something they can void the policy on, and our investigation, the policyholder's one, says it's not, and that's successful, then legally, can the the policyholder claim the cost of that back as part of the claim, because they've been forced to undertake it by the insurer, and if they hadn't, the insurer would have kicked the claim out?
Yeah, I think it's tricky. I mean, just to sort of echo what we said earlier, you know, for any claim over £100,000, I mean, I'm so sceptical of forensic investigators acting for insurers now, Angus, and I see so many problems caused by that sort of going down a factual route in that direction from day one. For any claim over £100,000 or large losses, I just think it's so important for a policyholder to obtain their own forensic evidence. But in answer to your specific question, can you recover it from an insurer? I'd say no if you only obtain forensic evidence and actually the insurer, before they avoid the policy, goes on to confirm cover. It's a sort of there's no basis, from my perspective, no legal basis on which to claim that cost back from an insurer, unless you've got some type of extension to your policy itself. I don't know. I mean, that's probably a question for the brokers. But it would be different, for example, if you, because of the way in which an investigation was going, or from day one, you obtain your own forensic evidence. The insurers then went on to allege wrongfully dishonesty and fraud. Once the policy is avoided, if it's voided unreasonably or unlawfully, that's a breach of contract situation. And in the same way that you can recover legal costs from an insurer for obtaining coverage advice, you would also be able to obtain, in my opinion, disbursements such as experts' costs and the cost of a forensic investigator, sort of right back from day one. I mean, there may be arguments the other way, but there's two contrasting situations. Hopefully that answers.
Thanks. Dan, I don't think you're looking at the questions. The question about policy cancellation and fraud register and how many years on that. Is that something you'd be able to address?
I can't remember how long it goes on for.
No, I can't either, actually. That's a very good question.
I wish Roger Jones was on the call. I'm sure he'd be able to tell me. Maybe you can message us privately. But I would imagine it's in addition to 6 years. But there must be some type of statutory. I don't know the answer to that off the top of my head, to be honest. So I'll look at that and try and answer that separately when we follow up. Or if that person wants to email me, that's fine.
And I think there's one more question here for you before we wrap things up.
Yeah, are you seeing more claims where insurers and adjusters are alleging fraud? I mean, on the basis that they probably end up on your desk, you're seeing a wider range than we are. I mean, are you seeing in the last few years? Is it difficult to say with the sort of 2-year COVID blip and everything's sort of gone on hold?
I think it's difficult because if you think about my role in the market, Angus, by the time it's found me, and things only come my way or find their way to Wynterhill, by their very nature, there's something unusual or difficult about them. So I sort of see a disproportionate amount of the allegations of fraud and the difficult stuff. Sometimes legitimately, sometimes there are issues with what the points the insurer has taken. But what I'm trying to say is what I don't see is the percentage that I don't see outside of that, where 99% of claims get paid according to Zurich Insurance. So I don't know in that sort of optic how many of those are looked at, but to then paid from it. I mean, they take a little while to come through as well. So quite often, what quite often happens is the allegation during the investigation stage is made. We're not instructed early on. Sometimes we are, but more often not, we're not. More often than not, we get instructed at the back end of it when it's all gone wrong and we're trying to unwind it. So it's that much harder.
Indeed. The cynic in me, acting for policyholders, would say that they might pay 95% of claims, but what's the percentage of the correct value of claims they pay? But I mean, the other aspect to that question is the evidence that is relied upon realistic or speculative? And certainly from over the years, and certainly in recent years, I've seen an increase where, let's say, insurers aren't actually putting it in writing saying this is a fraudulent claim, but they're certainly dropping hints that there are areas of concern they're worried about, and they've maybe got a special investigator involved or looking at other things. So they haven't gone on the record as saying this is a fraudulent claim, but they are reservation of rights and there's areas of concern. And in the majority of ones in my experience, whether I've been dealing with it or my colleagues have and I've got involved, I would certainly say 90% of them, the evidence is very speculative rather than realistic. Because the question here is the evidence relied on realistic or speculative. And I am amazed sometimes at the things that cause insurers to be concerned, in inverted commas, and even to the point that, as we both know, insurers have their red flags and they have their standard systems that if there's 2 or 3 red flags on a claim tick up, they automatically need to investigate it. And that can be for the most speculative of reasons and for the most genuine of reasons.
Yeah, I mean, what I would say in terms of a trend that sort of dovetails this question is that we are seeing more and more the disputes that I am involved in on PDBI matters where there are allegations of dishonesty and fraud. As a trend, what I am seeing is that they come from more and more from specialist fraud investigation teams. Angus, day one, specialist fraud forensic guy, on the other side, fraud adjuster, and then, like the case that I was dealing with, the head of fraud at a national law firm, and that's a lot of sort of intellect and resource on their side. And here's the kicker for me, and my concern is that when you have people looking at these issues day in, day out, and they're not looking at broader claims and how to treat customers fairly, give them the benefit of the doubt, or to interview them fairly, that what you see more and more is a degree of unconscious bias. So their starting point is highly suspicious, that I think is sort of a byproduct of just being in that team and thinking, like having a certain type of mentality. It's very difficult to prove, but I certainly think there's something in that. And I know some of the academics looking at issues like this in the industry, and that's what I was trying to get at, in my sort of statistical sort of comparison about how many claims there are out there.
Actually, just a quick one before we close up. Another question's come in related to that, which actually is quite an interesting one. That somebody's asked, is speculative evidence permitted to be submitted in a court case? Perhaps, would you be able to answer that?
Well, you can submit whatever evidence you want as an insurer or as a claimant. It's an interpretation, isn't it, as to whether something is A, credible, or B, speculative. In my case, the Ombudsman actually found that, essentially all of the insurer's case was speculative, and there was, genuine reasons why the insured had sort of got muddled up with, what had happened factually. So ultimately, to answer the question, what is speculative evidence? An insurer will say it's not speculative. They've got forensics. They can prove that the business was failing. There isn't a credible explanation as to where the policyholder was the night before, and they join it all together. It's more inference, I think. The difficult claims, the really difficult sort of disputes to handle and determine one way or the other, whether you're insurer or policyholder, actually, are the ones where you haven't got the evidence isn't complete. Like, no one really knows because they weren't there. The forensics is uncertain. So, they have to join things up and conflate evidence to build a theory and a picture and a narrative. Okay? And for me, once they do that, it is speculative. But I'm going to be told to shut up now. So.
I would never tell you to shut up, Dan. Dan, thank you so much. Angus, thank you so much. That was wonderful, really interesting. Thank you for all those that were with us today. Thanks very much for all of your questions as well. As I mentioned at the start, this has been recorded today, so we'll get a copy of this out to everybody within the next few days. And last thing, if you are at the BIBA conference in 2 weeks' time in Manchester, both Angus and Dan will be on the Lorega stand. If you have other questions, you want to talk more about this subject, please come along, meet them, talk to them on the stand, and we certainly hope that we'll be able to do that with some of you. So thanks very much. We'll say goodbye to everybody now, and again, really appreciate you being here. And again, thanks Dan, and thanks to Angus.
Thanks everyone.
Thank you. Thank you.
Bye-bye.
Bye.